Okay, then I'll start by saying hi. I see some familiar names and people I don't know. My name is Daniel Dorff. I'm on the New Music Committee and a clarinetist and composer. And part of what I do also is running the publication department at Theodore Presser Company. My colleague there in our legal department, in Presser and Carl Fisher, as we're partner companies, is Jay Berger. And Jay is a copyright lawyer. He's worked in the popular side of the industry for, I don't have my notes in front of me, but you did, what, 15 years or so
Yeah, about
doing that
15 in popular
before
music.
coming over to our company.
Yeah.
So Jay brings a very broad experience of a wide variety of music from several different decades of traditions and is certainly on the cusp of everything that's happening now with all the changes in the last few years, both from technology and the way that everybody's use of technology grew tremendously during the pandemic because of online concerts. So you are in for a treat, and also free legal advice. It, it's I say that very seriously, even though it's fun to work with Jay because he can tell us quite a lot that's very valuable to know, both as creators of copyrights, as some of you are, and as users of copyrighted music, as I guess all of you are. So I'll turn it over to Jay. We will take questions periodically, or you can type them to Jessica and she'll add them. Go ahead, Jay.
Thank you very much, Danny. Yeah, hi everybody. Thank you for having me today. And we're going to go over a bunch of stuff about copyright. A lot of people always get nervous when they hear the word copyright because they think of 13 different things, but you can really narrow copyright down and make it something that's pretty easy to handle and deal with. So what I'm going to try to do today is basically a couple things. Number one, I'm going to kind of walk you through copyright to show you that it's not like the worst calculus exam you've ever taken in your life. And then we're going to talk about how to get permissions if you want to upload your music or videos to Spotify, to YouTube, to Facebook. We're going to talk about those things as well. We're also going to talk about the industry in general. We'll talk about publishing, and we're talking about what you can basically do to protect yourself, what you can to basically get your music out there, promote yourself, and hopefully make a couple of dollars. So let's talk about a couple of things. First, we're going to start with copyright. The biggest thing about copyright, you got to think of it in two forms. Number one, the first form is you create your own intellectual property. You go into to your clarinet and you're making your own works, and you want to create that work, and it's solely yours. You're not using anyone else's pre-done material. You're not using an old copyright. You're not using something in public domain, but you're using something that is wholly yours, that you came up with, you created it, and there's no one else involved in that. So copyright is pretty simple now. What they've done over the years is try to make it easy for people to file a copyright. You can actually go to the United States Copyright Office website, and it's pretty much like $40, and you can copyright your own work. Okay, all you need to do is fill out the forms on the copyright website, upload either a recording or the sheet music to your new work, and probably about 4 to 5 months you'll have a copyright, and that will protect you. And we'll go into protections in a second. But so there are two ways actually. You can get another way for a copyright. Back in the old days, it used to be what's called the poor man's copyright, and you can still do that today. Sometimes copyrights can be expensive. If you come up with, say, 10 or 11 original works, I mean, if you multiply that by $40, it kind of gets high up there on the income, what to pay for. So basically what you can do is this thing called the poor man's copyright. And I tell a lot of people to do this, especially if you come up with an album and you don't want to pay the exorbitant fees at the Copyright Office. All you need to do is put your original sheet music and put a recording of that work in an envelope, address it to yourself, mail it to yourself, and when it comes in the mail, never open it. Okay, you only open it if you find that someone has stolen your music or used your music. That's called the poor man's copyright. And basically that gives you, if you look at your cover of your envelope, it gives you a date that it was mailed. And that date is when for copyright purposes, when your protection will start. So if you ever need to prove when you created the work, you have that envelope that has that stamp on it, says, I created this on January 2, 1999. And when someone tries to use it, you say, wait, you've used my work. And it actually does work. I've been in court several times on these poor man's copyright, and it does work. The only difference is if you were to have to go to court and enforce your copyright, if you file the regular copyright at the Copyright Office, you can get up to $150,000 in damages if somebody intentionally used your work. When you do the poor man's copyright, you're pretty much only going to get what the person who stole your copyright earned. So it could be a lot less. If they earn like $1.22, that's what you're going to get. A lot of times courts will issue a little fine as well. But if you have the ability to file a copyright with the Copyright Office, I implore you to do it that way. And it's really gives you a lot more protections and gives you the potential, if someone really does intentionally use your intellectual property, that you'll get a nice chunk of change for a person stealing your work. Now, the question now is, how long does a copyright last? And that's an issue that has changed over the years. Prior to 1978, the copyright was 95 years. So if you created a copyright in 1950, you add 95 years to that, and that's how long your copyright lasted in the United States. Okay. However, in 1978, they changed the law, and the law now is it's life plus 70. So if you yourself created your own work in 1992, it would last for your lifetime plus an additional 70 years. Now, that pretty much is a law in probably about 99% of the countries out there in the world. It's life plus 70. So those are one of the things you're going to look at, in terms of length. If you created something back in 1950, it does last 95 years. But every year, which is very interesting, if you want to do, put like this, your own arrangement on some work that comes PD, every year, PD is now changing, okay? Because the 95 years is expiring. So things from like 1926, 1927, 1928, if you go each year, a lot of copyrights are now expiring in the United States, okay? So you have to look when the copyright was issued, if you want to use someone else's work, and just count the years. Now, there are a couple of ways to do this. I'm going to give you a couple of tricks of the trade. There is a website called worldcat.com. Okay, now
.org.
worldcat.org. And you can plug in the name of the work and the composer, and up will come the copyright that was created for that work. And you can see the year, and then you can do your addition as to whether or not it's under the 95 years or under the new act, which is this, life plus 70. Now, one thing that you must understand is that sometimes copyrights can become PD in the United States, but not worldwide. For example, if you created a work in 1925, it is PD now. But if that composer died in 1990, it would still be viable in countries that are life plus 70. So just because something is PD in the United States does not make it PD, public domain, in countries all around the world. You still have to do your addition. You still have to find out when that person passed away. If they're still alive, it's still going. But those are the two things you really have to look for, especially if you're going to do someone else's work. If you're going to do your own take, you're going to do an arrangement, you're going to do a transcription of someone's work, you have to see if that work is still in copyright. That's why a place like worldcat.org is fabulous, okay? Because it will go
if I can just add into that, a great example is Stravinsky.
Yeah.
Because he died in 71, so his work is protected for a long time after that. But all of his works up through 1926, or all of his works that were copyrighted through 26, have lapsed into the public domain in this country. So, say the three pieces for solo clarinet is public domain here, but not anywhere else.
Right.
And same thing with a lot of 20th century composers. Gershwin, it's been the opposite for later Gershwin works, that for the same principle, since he died a long time ago, his music is public domain everywhere else, but his later works are still protected here. Year by year, they're dripping away.
Right. That's why you have to go in and look what the year is, because year by year, things change. And what's most important now is because we're in a new digital age, a lot of sheet music, if you create your sheet music of something that you think is PD in the United States and you're selling it on a website, maybe you're doing your own publishing, which we'll get into in a minute, or working with a publisher, if someone can purchase that product in another country and that composer is still within the Life Plus 70, you could be committing copyright infringement. So you really have to look at, is it PD both in the United States and PD around the world before you make a decision where you're going to sell that work. Extremely important. We've had that issue come up a lot of times. For example, when Danny and I do books together, there are some works that are PD in the United States, but not overseas. So we believe, so we can't sell those products overseas. So what we put in our own system is we can only sell these in the United States, okay? Unless we get permission from whoever is the publisher of that work, which we'll get into in a second. But that's most important. Things could be PD in the United States, but not overseas. So you really, really have to look at that. Now, when you talk about permissions, this is kind of like, it's an interesting topic because a lot of people don't know, number one, if they do need permission. Number two, where do we find out who owns it? Number three, how do we get permission? Permissions are a very important part and parcel of our industry because a lot of times people want to do their own arrangements of an existing work that's under copyright. Sometimes people want to do method books and they want to use little excerpts or snippets of other people's works that are still under copyright. You need to get permission. You cannot use someone else's work unless it's PD in either the United States or overseas, depending on where you want to sell it. If something's still in copyright, you have to contact the publisher. Now, publishers are usually pretty good at responding and giving you a quote for your use or something like that. But the question is, how do I find the publisher? That's always, I get a lot of emails from people who are creating books and they said, well, I know that you're the publisher for this work, but how do I find out who publishes this work? I don't know where to go. I don't know, how do I find out? Like, who do I contact? So I'm going to give you a couple of little cheap ways to get to it, okay? Since a lot of you are performers and composers, you may be affiliated with a couple of agencies, the performing rights agencies called ASCAP or BMI. If you, ASCAP and BMI permit public searches. And what I mean by that is that, for example, if you wanted to do your own arrangement of a work in copyright, you can plug into the search bar on the public search functions of both ASCAP and BMI, the title of the work and the author, the composer, and up will come up the registration, which will show you who the publisher is. The best part about BMI and ASCAP is they also give you contact information. They'll say, here's a phone number, here's the person's email. They'll give you that information so then you can go either to the website or that person's email and send them a request that you want to use the work. Now, a lot of companies like Theodore Presser and the other company, Carl Fisher, that I work for, we have on our website forms to fill out for permission. So sometimes if you find out, for example, that Music Sales or Hal Leonard is the publisher of a work, you can go onto their website and pretty much all the publishers have a licensing tab where you can click on and it'll pop up all the different types of licenses that are available. And you click on the license you need, whether it's if you want to do a video, it'll be synchronization. If you want to do a book, it'll be a print license. If you want to do your own arrangement to perform, there'll be an arrangement license. And you can fill out the forms and that form will directly go to the person like me who's sitting in his or her office and will get that request and we will respond to that request. But the big thing is, how do you find it? That's why you have to go to either BMI or ASCAP, or actually you can also go to the Harry Fox agency, which we'll get into in a second, and they'll give you that information as well. But the most important thing is you have to go and locate. And the best way to locate is using, in my opinion, two things, either the WorldCat that we just gave you, ASCAP or BMI. Now, WorldCat will not give you the contact information. It'll just tell you who the publisher is. But if you go to ASCAP, the public search tool, you'll find out who, where, and when to contact. Okay.
If I may add.
Sure.
So WorldCat is a library information. So that will show you what is the copyright notice on the book. If the owners have changed, they won't know. They tell you what you would see in the book, but it's a great start, and you can also find music that way. One of the nice things with ASCAP and BMI searches that has changed only in the last few years is because so many people start with, okay, where do I look? Half the composers are one, half the composers are the other. They merged their databases, which was a really wonderful thing to do for search, because now you can go to either and it will tell you, I mean, imagine, like Coke and Pepsi telling you where all the different stores are together. So that's very helpful for looking. And another resource is the Music Publishers Association website, which is mpa.org, MPA like Music Publishers Association. That actually has a number of resources for the general public and more resources if you are a member, but it includes a database of which bigger publishers represent the rights for smaller publishers, because a lot of times you may find, particularly with pop music, but also with concert music, you do find out who the publisher is, but then you can't find them even on the internet. You don't have any address for them. Well, it turns out that they've delegated all of their rights administration to one of the larger publishers, which happens a lot. And the way you can find that out through mpa.org.
Yeah, it's a good source. Also, what I do sometimes, if because there are times where we've never heard of a publisher, like we have a composer that wants to use a work in his or her book, and this publisher is from like 1825, or this publisher is from like the early 20th century, and they no longer exist. So another thing that I use, and don't laugh at this, is I'll actually plug in, I'll do an internet search, and I'll say, who owns X? I'll say whatever the publisher's name is, all right, who now owns, ABC Publishing? And a lot of times will come up, they are now part of Music Sales. They are now part of Schirmer. They're now part of, Hal Leonard or something like that. So there are times where the publishers no longer exist and they've been bought and sold plenty of times. There are plenty of times where, for example, it'll say somewhere that Theodore Presser is doing the administration where we don't do it anymore. So there are times where the information may not be 100% accurate, but if someone comes to me, what I typically do, and I think a lot of people in my chair always do as well, is that if you come to me and say, hey, I'd like to get a license on this work, what I'll do to help you is I'll respond saying, unfortunately, we no longer issue licenses for them, but I'll give you the contact name. If you're nice to these people, they'll be nice to you. I always try to help people out. So if someone comes to me and says, hey, I want a license for this work, I'll say, I'm sorry, it's not ours, it's owned by this company. And I'll give you the contact information, either the website of the main company with the licensing tab is, or if they don't have one, I'll give you a contact there so that you can contact them. So sometimes it's difficult. There are a lot of old publishing companies that no longer exist, and they've been bought and sold 100 times. So sometimes it is a game. Sometimes it's like a tough game to find, but you can end up finding it. It's not difficult. You just have to do a little bit more research than you thought you'd have to do, but you can find these. That's why a really good avenue really is ASCAP and BMI, because they'll have the most current registration for that work. So if it's switched hands from one company to the next, you'll have that there. So
Jay, can I move you to the next topic?
Sure, absolutely.
Because time flies when we have fun, which we are.
So let's talk about more about the permissions and stuff like that, and what you're going to need permission for these days. So basically, what COVID turned us into is we became more of an upload world. Okay, orchestras and philharmonics nationwide and around the world had to cancel performances. Okay, they had to cancel performances. And how did they keep their patrons? How did they keep their sponsors? How did they keep their people interested? They uploaded videos. Okay, the question is, how did they do this? Number one, they did it two methods. The first method is called a live stream. Okay, and the second method is just a strict upload of the concert to their website so that people can view it for as long as they wanted to. If you're doing a performance, and so many people during COVID did this, if you're doing a performance on Facebook, if you're doing a performance on YouTube, the question is, if you're not using your own original work and using someone else's work, do you need permission? Okay, do you need permission from the publisher who owns that work to do your live stream? Now, there are two avenues of thought here. There's one avenue of thought that says you're doing a live stream. A lot of publishers have these licenses with YouTube and Facebook, and you get paid from YouTube and Facebook, so you don't need to get the permission. The other stream of thought is you do, and I'll tell you why. I take the position that since you're uploading a video of yourself performing, that is what's called synchronization. You're synchronizing an audio and video component vis-a-vis this concert, okay? And we're only talking about live streams right now. So basically, in a nutshell, I take the position that you need a license from me because you're uploading an audio-visual work that includes my owned work. So I do charge a fee. Some places do not charge fees, but most of my colleagues who sit in my chair are charging fees on live streams. A lot of people think it's an ephemeral broadcast, and you don't need to, but it really hasn't been set in stone. That's why a lot of publishers will say you need to pay me. So if you are—
And that only applies to the actual real-time performances
yes, that's
themselves.
the real-time performance.
The archive is a different story.
Yeah, the archive we'll get to in a second. So what I suggest to you, no matter what, because God forbid, I don't want you to get in trouble, if you're going to do a live stream of someone else's work, contact the publisher. Go to WorldCat, go to ASCAP, go to BMI, find out who the publisher is, contact that publisher and say, I'd like to get a synchronization license to do this live stream, okay? Because there are people, like I said, that will say that if you don't get permission, you've infringed on our copyright by uploading a video using our song. So I implore you, contact the publisher. The publishers may say, hey, here's for 25 bucks, we'll do it. Or the publisher may say, do it for free, but contact the publisher. Now, this is completely different than when you've already had your concert, you have the video from your concert, and you want to put it on your website, or you want to put it on YouTube indefinitely or a specific amount of years, whatever, however you want to upload it, okay? At that point, when you're taking the video that you've already recorded and you're going to upload it to YouTube or Facebook, you must get a synchronization license. No ifs, ands, or buts. When you take that pre-recorded video and you want to leave it on YouTube for 30 days, 60 days, or in perpetuity, you must get a license. And if you don't get a license, two things could happen. Number one, the YouTube police will probably take it off. Facebook will probably take it off because you're infringing on a person's copyright. So when you're uploading that video, get the permission. Now, the question is, how much do these permissions cost? Basically, it depends on the publisher. Some publishers are, I'm going to say this diplomatically, want as much money as they can get. And other publishers see that, for example, we take into account when I sit in my chair and I get a request, I look to it, see, is it just an individual? Is it like a school? Is it a professional organization? Is it an amateur organization? I really look to see who the person is. So I take the position that, and some of you people may have contacted me for a license. If you're an individual and you want to put up a video for 30, 60 days, the fee's not going to be that high because you're an individual, okay? If you were the Boise Philharmonic, the fee would be much higher, okay? But I do take into account, a lot of people do, who the person is. And when you write your email or fill out the form to get your permission, tell the publisher that you're an individual, that you're an amateur group, that you're just doing this for, for 30 days, and you just want your friends and family, whoever, to see it, okay? Explain to them who you are, because we will take that into consideration. And that's very, very important. To take that in consideration, because you're different than, the Metropolitan Opera. You're not going to get if you came to me, I'm not going to quote you the same fee as the Met, okay? Because you're an individual. So I do take that consideration, but please, when you really reach out to these people, tell them who you are. That will mean something. Okay, an unpublished work. That's a great question. Okay, what about a performance of an unpublished work? Okay, if the work is unpublished, that means there's no copyright. It's never been out there before. The question is, will you have to get permission? Okay. If it's an unpublished work, the answer really is you don't need permission. And I'll tell you why. If there's no copyright that's attached to it, there's no either poor man's copyright, there's no registered copyright, no one's ever put it in sheet music before or anything like that, nothing has attached. There's two ways protection has attaches. Number one, if it's published, even if there's no copyright, that it's already out there, or two, if there's a copyright. So if it's an unpublished work, what I would do, to be honest with you, if you know the person, I would ask that person. If the person is anonymous, or you don't know the person, or it's it's an older work or something like that, if it's unpublished and you can't find a copyright and there is no copyright on this work, you can go ahead and perform that work and put it on a video. The composer died. Okay. If the composer died, again, if it's not published and there's no copyright, you're safe. If it was published, then you would need to get permission. You'd have to find out, number one, is it public domain? Is the composer dead more than 70 years? When did the composer create it? But if it's unpublished and the composer died, you should be fine. There are a lot of other licenses that you may have to deal with at times. Like, for example, you may come up with your own arrangement of a work that's already in existence, and you've done your own little arrangement to it. Like, for example, you've done it for a different instrument, or you made the arrangement in a different key. If you want to sell sheet music of your arrangement or any other music that you have that's not yours, again, you will still need to get permission. That is called a print license, okay? And you'll have to get a print license from the publisher, okay? So if you want to put your own spin on something and put it out there in sheet music form to sell, you'll have to ask the publisher who owns that work for permission. And typically these fees are like, the standard in the industry is 15% of what you're going to sell it for times the number of units you're going to sell. So if you want to sell 100 units at $10, you do the math, it's 100 times 10 times 0.15, and that's the standard fee that you're going to pay to get permission to sell that. Okay, so print licenses, a lot of people come to us and say, hey, I know you have this. For example, one of our composers by the name of Ernest Bloch. Okay, he has a lot of great works that some are PD, some are no longer PD, but people love his music and they want to do their own arrangement. So they come to me and they'll say, hey, I want to do a specific violin arrangement of this work. Do I need a license? And the answer is yes. If it's still under copyright, you need a license. So print licenses are kind of interesting, and sometimes you can. Okay, fair use doctrine. Fair use doctrine. That's a great question. Okay. I'll give you an example of what is fair use. We have a composer that's created an incredible piece of music, kind of a social justice music called Knee on a Neck. Okay. And basically what happened was NBC News came to me and said, hey, we want to go to the premiere of this work. We're going to put it on our nightly news and our affiliate news channels in various cities across the country. It's a news report. Okay, so the question is that fair use? And the answer is yes. Any type of news story about a composer is fair use. Like, for example, if everyone remembers when Michael Jackson passed away, every TV station in the world was playing a clip of Michael Jackson, probably doing either Beat It or Thriller or something like that. You don't need permission, okay, if it's a news article or newsworthy. So for example, if they publish a picture of a composer in a newspaper who just passed away and they're reporting on his or her death, that's fair use. If they post a video, if they're doing a story on the news and you hear the music in the background, that's fair use. There are 4 factors that go into fair use. Education is one of them. But the question is on education, is it really educational use, or are you making, like, for example, a textbook that has music in it? That is not fair use. Okay. If someone creates a textbook and they're saying, well, we're only doing it for educational purposes, like I say, my famous line is that and 275 gets you on the subway in New York City. Okay. If someone's creating a textbook and they're going to sell it to college students, and everybody here who's been to college knows how much those textbooks cost. Okay. That is not fair use. Fair use really is kind of, it has to be news. It has to be something to the effect where there's no gain. Anytime there's a potential to gain money from something, okay, even if it's a small potential, fair use goes out the door. So even if you come to me and say, hey, I think I'm under the educational factor, but I'm selling my book, I'm like, you lose. It's not fair use. Okay, so fair use can only be used basically in news and purely educational. For example, if you were a teacher and you were to play a song in your class to instruct your students about the song, how to play the song, etc., that's fair use. Okay, but if there's any type of monetary, even the small potential of monetary gain, your fair use doctrine goes out the door. It just doesn't work. And you
Right.
can,
So, oh, I'm sorry. Since
oh,
Oliver's question was, how does it relate to IMSLP?
okay, so
I want to
that's the next
get
one.
back to that because IMSLP really doesn't have anything to do with fair use. It has to do with copyrights expiring.
Yeah.
So, and and they're a terrific example of the problem with international copyrights being different from country to country. Because IMSLP, after in their initial years they got sued enough, they finally became very careful. But they also have a lot of loopholes, as probably you've all seen, that it will say this is not
Copyright.
public domain yet in your country, and then they send you to another server like Asia dash IMSLP because they can't download it from Canada, which is where they're based. But actually, I find IMSLP is a good source for copyright information because their lawyers check, when's the
Sometimes
first
they do.
edition? Yeah.
Yeah, sometimes they do. We just had about a month ago, our new string orchestra editor wanted to do this work, and IMSLP said it's in the public domain in the United States. And I did research on it, and even on the page at IMSLP, it said 1951. I'm like, wait a second. There's no possible way, if this was created in 1951, that it could be public domain in the United States. And it wasn't. And I found the copyright and it wasn't. So it's a great place to start if you're looking for something, but you need to double check, okay? Because although they have people looking at it, it's not always 100% accurate. They are trying to be as accurate as possible, but sometimes they are not correct. So please don't take it for, the gospel. Do your research on it. And
Yeah,
that
and
we
this applies to what Jay and I deal with. That I think clarinetists are very have similar experience in trying to get things. Sometimes there's an excerpt book we've been working on where a piece we found that there was a 1925 copyright on it. We thought it was public domain. We didn't have to license permission to have the excerpt until we discovered that only the piano version of this piece was published in 1925. The orchestration came later, and we were doing an excerpt book. So the intellectual property is a different layer. And this actually maybe is something we should talk about, that different layers of intellectual property. For instance, everybody knows Carol of the Bells, which is one of Carl Fischer's great copyrights. The underlying music is from the 19th century or the early 20th century.
yeah.
Yeah, the tune itself is old, but the words are more recent and still protected. The biggest thing with this is folk songs. And let's say Simple Gifts. How many people have made arrangements of Simple Gifts that are not based on Aaron Copland? So many of us know Copland's adaptation in Appalachian Spring, but the original song is public domain. So if you go back to the original intellectual property has expired. The later adaptations have not, and this is why Firebird and Petrushka, the original versions of them are more than 70 or more than 95 years old. And the copyright laws were different. Stravinsky, part of the reason why he made those newer versions was for musical reasons and with Petrushka to make some of the rhythms easier to read, but also so that he could copyright something in free Europe because he had copyrighted it in Russia where there were problems. And now it turns out that the original versions have expired. So sometimes an excerpt book will have the original version of Firebird or Petrushka, but not the later version because they couldn't get the rights for that.
Yeah.
Histoire is even more complicated.
Yeah, it's very, very interesting. Like a lot of people, they hear a song and they're like, wait, that song is like 1,000 years old. And that's the issue. And I'll tell you a couple of stories about Carol of Bells. I mean, um, Carol of Bells, basically, like Danny said, is a Ukrainian folk song from 1908. It's called Shedrick, actually. That's the name of it. It's called Shedrick. And the lyrics to Shedrick say, if a swallow flies into your house around New Year's, by spring, you're going to be the wealthiest person in the world. It's a crazy folk song. It's a kind of a fun folk song. So in 1936, the gentleman by the name of Peter Wilhowsky heard this song and said, wait a second, am I missing something? That would be the greatest Christmas song known to man. So what he did was he took that underlying instrumentation, the music portion, which was public domain, okay, and he just put brand new lyrics and he called it Carol of the Bells. So you would not believe how many people think that the 1908 version Shedrick is Carol of the Bells. So people use it all the time. They use the lyrics. They don't understand. And my one favorite example is when my kids, this is about, I don't know, like 8 years ago or so, and I was at Carl Fisher and we were watching like Disney, okay? And all of a sudden the Muppets came on and the Muppets start singing Carol of the Bells. I'm like, what the hell? I didn't issue a license for that. And then it turned out that the gentleman at Disney said, oh my God, I thought it was public domain. Isn't this from 1908? I'm like, no, it's not. So you really have to check because songs can be changed. I mean, arrangements can be copyrighted. So
Right.
songs can be
And
changed.
so, as applies to clarinet players and arrangers, for instance, a very common piece that comes up, let's say, is Greensleeves.
Yeah.
Beautiful piece, good to do for your Christmas concert. You can make your own arrangement of any version of that melody that's from before 1926.
Yeah.
But you can't use the Vaughan Williams because he added an extra layer of intellectual property, and that layer is protected.
Right. And that's the thing that you have to understand is that you could use, if you want to create your own arrangement to a public domain work, you can then copyright that. Okay, that is your intellectual property. You can make a change to it and that becomes yours. And if anyone wants to use your version, okay, not the original, they need a license from you. So you have to understand that you can make changes to PD works and they become your intellectual property. But then like a lot of times people come to me and they'll say, hey, I want, I'm looking for X work. And I'm like, well, I have this, are you using the original from like 1825 or using my arrangement? I'll say, no, I want the original. I'm like, I can't stop them. They're not using my arrangement. If they're using the original work from 1825, that is public domain. So they can go ahead and do that. So it's kind of interesting. There are a bunch of other licenses. You people may want to put your works on a CD. You may want to put your work up on Spotify or something like that, or you may want to create digital downloads. A great place for mechanical licenses is called the Harry Fox Agency. If you want to do a cover work of someone's original work, you can get a license from Harry Fox online, pay the money, and you're good to go. Okay, so if you want to do, for example, if you want to do the clarinet version of Carol of the Bells, okay, you can go to Harry Fox and you can get a license from Harry Fox in about, I would say, maybe 35 minutes max, and you'll be able to perform you'll be able to put your work on a CD or ringtones or digital downloads. Okay, so mechanical licenses are very easy to obtain. Most, I would say probably in the United States, about 95% of the publishers in the United States are all affiliated with the Harry Fox Agency. So their works will be on Harry Fox. If not, you can go and contact the publisher using the way I told you before, finding them out through ASCAP or BMI, getting their information, going to their websites and completing their forms. So you can get mechanical licenses very easy. Now, the one thing about a mechanical license is the publisher cannot, unless it's the first time you're recording their work, the publisher can't say no. These are what's called compulsory licenses. So for example, if you want to go do Carol of the Bells, that has been recorded, I would say probably 17 gazillion times. So when you come to me for a license to do your recording of the Carol of the Bells, I can't say no, I have to say yes. However, if you know of a work that's by a publisher that has never been recorded before, and you will be the world premiere recording on a CD or a digital download, there's something called first recording rights. This is the only time where a publisher can say no, or a publisher can say yes and give you an astronomical rate. Mechanical license fees are statutory under the Copyright Act, okay? Depending on if your work is less than 5 minutes, it's one calculation, which is 9.1 cents per unit, or if it's above 5 minutes, depending how long it is, it's a different calculation, but they're statutory fees. So if you are the second person to record a work and it's under 5 minutes and you want to do 10 units, it's 10 times 0.091, and the publisher cannot say no. Now, if it's the premiere recording of this work and you go to the publisher and say to the publisher, I want to do this, he or she can say, okay, we'll give you the right to this first recording, but we're going to charge you what we want to charge. There is no statutory rate for the first recording. Now, typically when someone comes to me and they ask for the first recording, I will charge them maybe 3 to 4 to 5 times the statutory rate if it's the first recording. So Danny comes to me on January 1 and he wants to record my work for the first time. And he wants to do 100 units. I charge him a pretty large rate. He says yes. He goes records. 2 days later, someone comes to me and says they want to record that same work and they want to do 10 units. I have to charge them the statutory rate. I cannot charge them more.
I got to ask you a question which comes up, and
Sure.
which is, it's awkward, not awkward to ask you, but so let's say you give me that permission and it takes me 4 more months before I go into the studio, and then another 8 months before the label puts it out. And then somebody in the meantime does it a whole lot more quickly. They're going to have the first release. So does it matter who releases it first or who contracts it
So
first?
what I do is on a release. For example, when someone comes to me and says, I want to be the first recording of this, and someone comes to me 3 days later, I said, okay, you can record this, but you cannot release it until X day, because the whole idea of putting a premium on the first recording is to give that person first dibs. So their recording should be the first one out the door. So when someone comes to me 2 days later, I say, okay, your statutory rate, but you cannot release until after the first recording is out. That's just the way I deal with it. That's the way a lot of the publishers deal with it, because it's not fair, because I've charged you a premium.
And is that equally applicable for commercial labels like Albany, as opposed to if I'm putting my thing straight to Spotify, I can do that much more quickly than waiting for.
Yes.
Is it, so does one supersede the other, or are they treated equally?
They're treated like it. Once you put it out, the way I look, if you tell me you're going to put out your record either on Spotify or CD on January 10th, right? So I'll tell the next person that who comes to me the day 25 minutes after you do. Okay, I'll tell them you cannot put this out until January 11th or the next day. I tell them specifically because I have an agreement, and I've charged this person a premium. They get the right. Their recording gets out there first before anybody else's. So you may have it all ready to go, but no, you cannot release it. And I think that's only fair because, like I said, I've charged you a premium. So mechanical licenses are pretty straightforward. Another interesting thing that people always come to me, they say, I'm doing a live concert tomorrow. How much do I owe you? I'm like, okay, that's a great question. If you do a performance at a concert venue, okay, and hopefully it's a concert venue that's doesn't have to be famous, but has a lot of concerts out there. The question is, do you have to pay a performance fee? Do you have to pay the publisher a fee to perform that work? Typically, the answer is no, and I'll explain why. Typically, venues, believe it or not, restaurants, cabarets, they all have licenses with BMI, ASCAP, or which sometimes we like to call the poor stepchild CSAC, okay, which is is pretty much the third out of the 4 performing rights associations, organizations, I should say, in the United States. If the venue has a performance license with the performing rights organization, you do not have to get a license from the publisher to perform. Okay.
And let me add that pretty much every university, college, conservatory does have such a license.
Yeah. I mean, there's the typical thing, like sometimes people have concerts at churches because, they have good auditoriums and the places, which we'll get into a second. But If the venue itself has a license, go ahead and perform. What'll happen is the venue itself is required. They've already paid a license to the performing rights organizations. They're required to send each organization a list of the works that were performed. That's how the publishers and composers get paid. Okay. So basically, in a nutshell, if you're performing Knock Wood, you're at Carnegie Hall, Madison Square Garden, Yankee Stadium, don't worry about it. You're covered. There are instances where it's not covered. So if someone tells me, yeah, I'm doing it at a local church or a community center or something like that, I'm going to ask you, does that center, does that church, does that venue have a performance rights license? And if they don't, then yes, I do charge you a very nominal fee for performing rights. Because the reason being is that that venue is not going to report the use to BMI, so I'm not going to get paid for your concert.
So yeah, and to add, if I understand correctly, as long as someone or some organization covering your concert does have the license, it can be either the venue or the performing organization, yes, as long as someone's responsible. And for most orchestras, chamber concerts that are under their auspices are under their umbrella. So
yes,
pretty much anything with school or professional orchestra. But now Oliver's question about community bands and orchestras.
Yeah, Jay. Community bands and orchestras, yes. You do need a performance license if that venue or wherever you're playing doesn't have one. I mean, you cannot have, the whole idea is this, and I'll explain to you the whole idea of performing right. Basically, in a nutshell, you people are very creative. You people create these works. You know what? You should get paid when your works are performed. You're not, listen, let's be honest. We're not Michael Jackson, we're not like a top 10 pop song where if we're on the radio or being performed in venues, we're going to make an obnoxious amount of money. You guys should be paid for your incredible intellectual property. So if a community band comes to me, for example, and they say, I'm doing this performance, I'm not going to charge them an arm and a leg, but I really want my composer to get paid. And I'll tell you why. Once the composer gets paid, that gives him or her the impetus to create more works. It says, oh, my works are being performed out there. You should get paid for what you do, even if it's a small amount. We like to say in our industry, even if we get $5 for our composer on something, that's $5 that, he or she's going to say, I want to continue doing this. If they don't get paid for it and they say, oh, my work's been performed here and there, why am I doing this? The whole idea is you're creative. We want you to keep creating. And that's why, when you have a performance, I'll ask, is it, do you have a license? Does the venue have a license? If not, I'll charge you very nominal fee, like maybe $15, $20 or something like that. It's not a lot of money, but I do it. And the reason why I do it is to make sure that our composers have something, they get something that keeps them going. I mean, we have to be honest. I mean, COVID was a rough time for a lot of composers out there. Their royalties for sales, their royalty for concerts went straight down. So when someone came to me and they said, we're going to do this thing, we're going to upload a video of this composer for 30 days. And Danny can tell you, I was charging the most nominal fees. I was inundated with licenses requests that you would not believe from schools, from community orchestras, from community bands. They wanted to keep their music alive. And the only way to do that was to post it on YouTube, was to post it on Facebook. So I wasn't charging an arm and a leg. Schools, I was charging $20. Community bands, I was exorbitant fee of $25. So the whole idea was, the fact of the matter is that, we needed to get these money. Okay, question, was the composer paid when I purchased the print music? Yes, but that's just the sale of print music. There are several different aspects of music, okay? And the reason why there are organizations, for example, like BMI and ASCAP, and now there's a new organization called the MLC, is that when a person's music is played, they deserve to get paid. And that's what those organizations do, okay? There's a new organization called the MLC. The MLC, the Mechanical Licensing Collective, deals with digital service providers. When your songs are played on Spotify, when they're played on YouTube, and there are hundreds of DSPs right now, Amazon Music, Google Music, believe it or not. So when the music is played, the composer of that music earns a fee. So that's the whole idea. It's not just a print music. For example, there can be people who play a song, they've heard it on the radio, for example, and then they're going to just go play it at their community band, and there hasn't been a sale of sheet music or a sale of sheet music. And I'm going to be honest with you, if I sell a piece of sheet music to a school, if I sell a band set to a school, for example, that set costs maybe $60. The composer typically in this industry gets 10% of that sale. So the composer is going to get $6. Now, if that song is then played umpteen times by a college, by a professional orchestra or something like that, he or she deserves to get that money. That's the whole idea. When the song is played out there, the intellectual property is heard by people over and over again. That's why there's a fee. Okay, that's why you have performances. You wouldn't have things like BMI or ASCAP unless there was another avenue of income, because with all due respect, sheet music doesn't pay the bills a lot.
If I can add, so the copyright, the legal entity which is copyright, it has been defined. There was sort of a gigantic lawsuit about the Stravinsky will, and his lawyers did this study that could be a book in itself. I don't know if it's really publicly out there, but they explained, and no one ever disagreed with this. They explained that the term copyright is an umbrella for many different types of interrelated rights that are divisible and can be delegated outright by right. So, for instance, this is just amplifying on what Jay was saying: the right to sell the music, the right to rent the music, the right to record the music, the right to make audio recordings, the right to make video recordings, which is a different situation from audio recordings, and several other, the right to sort of sublease third-party arrangements and publications. And so when you buy sheet music, you own the sheet music copy, that in itself. And in general, you don't have to worry too much about the performance right, because most of the places that you're playing already have that. They've taken it out. So all these performance venues, schools, big organizations, have what they call a blanket license. A blanket license means that every fiscal year, ASCAP and BMI go to them and say, okay, pay up for the fiscal year. And then you've got a carte blanche for everything you want to play during the year, but you have to send us programs so we know how to distribute it to the people who own those rights. And that's where it came from. And when ASCAP and BMI go to all these different organizations, they take into account a tremendous sliding scale. This is similar to what Oliver was alluding to before, and what Jay said, that when they go to the American Composers Orchestra, which does tremendous amount of copyrighted music, or let's say, any conservatory, they're going to require a larger blanket fee than when they go to a community orchestra that plays 5 or 6 concerts a year and might have 2 or 3 pieces that are still protected, based on their budget, based on their history of what they've done before. I am on the board of a local flute society, and we pay like $100 a year. Some of our concerts are at a university, but that's just to cover anything else. I didn't see who asked about if it's being archived, but yes, this talk is being recorded, and talk to Jessica to get the archive, I think.
Yeah, there are two more very good questions. Bill Shepard says, do you need to get permission to publish a transcription of an improvised jazz piece that wasn't written down, it was just performed? That's a great question. And my answer to that question is no. Okay, if it's an improvised piece, you've heard it and you're doing your own. If it's not copyrighted, not published, again, no protection has attached to it. So if you hear someone playing something and you like it and you want to do your own take on it, go right ahead. The time that protection occurs is when it either been published or it's copyrighted. So if you hear something that you want to do your own take on that's never been published, that's never been copyrighted, you're free to go do it.
So if I want to make a transcription of Eric Dolphy's improvisation on God Bless the Child, I've got the composer of God Bless the Child, who wrote all this thematic material that's used, and Dolphy's improvisation. And there are several of his improvisations out there. There are two people's intellectual property of a sort.
Right. It depends. I mean, if you're using if it's a piece that's in existence that has been improvised, that's different than if it hasn't been, if it's just played by somebody. That's the big difference. So the question I think more was, if you just hear it, it's never been written, it's never been, there's never been any intellectual property attached to it, then you're free. But if there's a work that's in existence and then someone did something to improvise or something like that, you're going to need permission if it's already been in existence and written down and something's attached to it. But if nothing is ever attached to it, you're free to do it. Okay, that's the big question. Okay?
Yeah. Now, Jay, you taught me something last year that I didn't know and I was surprised about, which is a lot of people who teach jazz have their students write new solos over chord changes to known songs.
Yeah.
And that's okay. I didn't think it was okay because that's adding a layer over intellectual property, which is the original chord changes. But you've explained to me that the chord changes themselves are not protected.
Yeah, the chord changes themselves are not protected. I once wrote an article, I'm dating myself now, about that, about like chord changes and stuff like that, because it's always difficult when you make a slight change. Are you doing something to the intellectual property work? Are you doing anything that creates intellectual property, or are you infringing? And the answer, unfortunately, is no right now. I did an article way back about the Beastie Boys had used three notes. They changed the chord on this. I forgot the name of the flautist, but changed a little bit of this flautist work. It was really 3 notes or 4 notes. And the court said that wasn't enough for copyright infringement. They just made a slight change to it. It was generic and there was no copyright that had attached to it. So it's kind of, it's a tough question. The question is, how much can you use and stuff like that? But chord changes are typically, they're not protected, unfortunately.
And when you talk about the courts and judges, one of the tricky things, and this also applies to the fair use doctrine, is that the law is deliberately ambiguous sometimes. The fair use doctrine says it depends on how much you take, it depends on how it affects the publisher's income, and some other conceptual it depends. There's absolutely nothing like 8 notes or 2 bars or there's no specific. Yeah. It's a conceptual thing. And this is why there are a lot of interesting lawsuits about this pop song infringed from that pop song. Well, they certainly have a lot in common, but sometimes, you can't copyright the 12-bar blues. There was this case with Alan Thicke and the Marvin Gaye estate a few years ago, where the words were different, the feel and the groove were the same. And that after many, many appeals, I think the last court said that, well, the groove is like the style. You can't copyright disco. The first person who did 16th notes and a hi-hat couldn't copyright that pattern because that became a style and not a work. But what it really amounts to is that you don't always know what you can get away with or what different people are going to think are infringement.
That is true. And I'll give you 2 examples. One case that I worked on myself was, I don't know how many of you out there are hip hop fans, but the biggest hip hop song of all time prior to a couple of years ago was Rapper's Delight by the Sugar Hill Gang. Okay. If you ever hear this song, you'll see that underlying is a song from the group called Chic. And they had used 7 or 8 notes that repeated over and over and over again. And the court determined that they had infringed, even if it was only 7 notes. So it really depends on what you're doing, okay? And suffice to say, Nile Rodgers and Chic made about $12 million on that because of the amount of sales that song. It was the most popular hip hop song for like 30 years before it was recently overtaken. Another interesting, people like to say, what is parody? Okay. To show you my eclectic style of music, I'm a big Weird Al Yankovic fan. Okay. I don't know if many of you are, but his stuff, it just makes me laugh over and over again. So what Weird Al has done over the years is that basically he can do these songs for free. When he does, if you remember Michael Jackson Beat It, he made it into Michael Jackson's Eat It. And he made some other songs. Basically they're parody. And if you do a parody of a song, that is basically you can get it for free, as long as it's parody. Now, to Weird Al's credit, what he does in every song that he makes, no matter what, even if it's parody, he always gives the original writers credit and pays them. So it's an interesting thing. Like, for example, Amish Paradise, he created, I think that's Wu-Tang Clan. He gave them credit for it. So if you're doing a parody song, technically you can do it for free.
Why is that not a cover version?
It's not a cover version because it's a joke and it's considered quote unquote parody. Technically, it is a cover version. It technically is a cover version, but because it comes under the guise of parody, that's why there's an exception. So that's why Weird Al gets away with that stuff. But he really doesn't get away because he's a good guy. I don't know him, but I could tell you that the way he operates in this industry is that he gives people credit. There's one more question that's really, really good. Just one second, Danny, and then I just want to answer this one question. It says, preparing an arrangement to suit its makeup, are there two copyright issues? Like if a small band wants to prepare an arrangement, are there two copyright issues then? Use of composer's piece upon which the arrangement is based, and then a performance consideration. The answer is yes, and I'll tell you why. When someone comes to me and says, I've got your piece for band and I want to add 13 different instruments to it, you are creating an arrangement. And I will charge you an arrangement license fee because you are changing the music. You're not just doing it. Sometimes people come with me, I just want to change the note. I'm like, okay, go ahead. I'm not too concerned about it. But when you add other types of instrumentation for the makeup of your band, it is an arrangement. So what we usually charge is an arrangement fee, and then we'll throw in another charge for, if you're doing 5 performances, a nominal charge for the 5 performances. But you're absolutely right. There will be a charge for the arrangement and the performance consideration because you have been performing that arrangement. Okay.
So there's this piece that's copyrighted and it's written for flute and I really like it. I just want to play it on my clarinet without changing anything. Kosher or unkosher?
Totally kosher. I just had that happen to me. I think it may have come through you, Danny. A woman had said to me, she was doing a work that was originally for flute, and she was going to play it on the saxophone. And she said, I am not changing anything. I'm just going to use the saxophone to play it. Gesei gesund, all good for you. Okay, go ahead and do it. Life is good. I'll do it. But yeah, if you're just using a different instrument to play an existing piece, and you're not making the changes on it, go right ahead and do it. But that's something that you can do. You're not really making an arrangement. If you think of it, all you're doing is you're playing it on a different instrument. So you're not making any changes to the existing sheet music. You're not making any changes to the existing notes. You're just playing it on a different instrument. One of the things I say all the time is like, if I make a violin piece for glockenspiel, but I'm looking at the same music that it would be for, the violin or whatever it was originally made for, you're not making an arrangement. You're just playing it with a different instrument. So it's okay. But those are interesting questions because, a lot of people, think that they need an arrangement license if they're playing a song for a different instrument. Only if you're changing the sheet music to fit that instrument. If you're just playing it just as written, you're good to go.
We're running through our hour.
Yeah.
Any last questions before we have to go?
None from Michael Drapkin, though. Michael Drapkin is not allowed to ask any.
Actually, I had a quick question.
Oh, geez, you're killing me.
Are we still respecting Russian copyright?
You know what? That is an amazing question. Okay. Okay. Here's the you can blame this on Ronald Reagan. Okay. That's how I look at it. Okay. Basically, in a nutshell, there was no Russian copyright prior to the fall of communism. Okay. So what happened after that, after the fall and the GATT treaty came, every publisher in the United States and across the country was running to get these Russian composers signed up. Now, a lot of publishers like Carl Fischer had existing arrangements of these Russian, like we had a bunch of Shostakovich, a bunch of other ones that we had. The GATT treaty gave you 5 years after the fall of communism, basically, to keep selling it. Okay. Once those 5 years were over, then basically you're out of luck. The publisher who signed that composer then owned the rights and you can no longer sell those works. Now, Russian copyrights. So Russia did not have any copyrights whatsoever prior to, like I said, the fall of communism. So basically now, there typically aren't any Russian copyrights. They're all through United States and European publishers right now. we have folk dances, that's one of our works that we can no longer sell because our time limit expired. So basically right now, if you want to get like a Shostakovich work or any other Russian work, they may be signed to different publishers. You're gonna have to check. But yes, there was no copyrights before. Now there are copyrights, but they're owned by major publishing houses now.
And most of those are through Schirmer or Boozy because of deals they had with the Russian publishing companies.
Oh my God. They ran
Yeah.
Schirmer and Boozy, whoever was running Schirmer and Boozy at the time, they are rocket scientists because they ran out and they said, holy crap, this is great music that, I'm going to get for next, bunch of years. So they ran out and they signed everybody. Anybody that they could, they signed.
Right. Okay. So Vincent has a question about commissions that I want to answer. When you commission a composer, there really needs to be a clause in the contract that says whether or not you're commissioning, like what is the status. Almost invariably, and I say almost invariably, in concert music, the concept of a commission is you pay the composer for the opportunity to premiere the work, to have it dedicated to you, to have whatever other accolades, but not to have a financial interest in the work's future. Maybe you get a waiver of recording rights or something, but not ownership. But if you and the composer agree in writing to do that, it's certainly subject to any contract. The legal default, if it's not mentioned, is that it belongs to the composer.
Yeah, typically what happens, and Dane and I do a bunch of commissions. Typically what happens is we'll put in the agreement that the composer, the copyright will be owned by either the composer or the composer's publisher. And that's what we put. Now, in a commission, there are a whole bunch of other little factors that go in as well. Little things like who gets premiere rights, who gets rights of first recordings, etc. But for copyright law, typically what happens in a commission is that the copyright will be owned by the composer and or her publisher. That's just the way it works. We're just doing, I'm doing like 5 right now with one of our new composers, and every commission agreement that we have written says specifically that the copyright is going to be owned by the composer and or her publisher. So that's,
and yeah, now there's a specific thing called a work for hire. And that's the other kind of contract. And that has to be spelled out. You may see, if you watch credits at the end of movies, sometimes it will say that this, and that were a work for hire. If, let's say you were commissioned to write a piece of music or a jingle for a film production or a TV commercial, whatever, it's pretty likely that that will be a buyout. They're paying you to deliver a product to them, which then they own. And that is a work for hire. And that has to be spelled out in writing. But I would say absolutely anything you ever do between a performer and a composer and a commission, spell out in writing, and don't count on anything to be a tacit understanding.
Yes. Make sure the most important thing when you do your commission, the most important thing is who is going to own that copyright. To me, that's the most important aspect of that. Make sure when someone commissions you to create a work that you're going to get this copyright. Just believe me, you want that, you need that, you should have it. It's your intellectual property that you're creating. I know when, for example, the commissions that I work on, there's no question that if the commissioners want the copyright, we're not doing it. We're just not going to do it, okay? Because that's the intellectual property. That's our composers creating it. Yes, are you paying for it? You're going to pay a commission fee for that new work, but in exchange, the commissioner usually gets, number one, the first performance, the first right of recording. On the sheet music, it's going to say commissioned by X, person or entity. So there are things that the commissioner does get in exchange for paying its money to commission a work. But the copyright does apply, does get to the composer and or the composer's publisher.
Yeah. Any experienced negotiator or good negotiator, I should say, knows that what the two parties have to talk about is, what do I really want? Or insist on? What do they really want or insist on? And what would I like, but it isn't the end of the world? Or what would they like and it isn't the end of the world? And that usually makes it easier to figure out how to adjust things so everybody's happy.
Okay, there's a question again. I never uploaded my transcriptions of Rimsky-Korsakov's 3 concerts for wind instruments to IMSLP because the copy was not copyrighted.
don't upload it to IMSLP
No.
unless you want to give it away.
Yeah, don't. And there are some other bad people out there too. There's another site called Scribd. If any of you have ever heard of that, if you have your music, it's in sheet music form. I implore you to go on scribd.com. It's SCRIBD.com, because the whole world may be looking at your music right now and you're not getting paid for it. I implore you. There's another one called PDF. Was it KPPDF.com?
There's
Another
so many.
one. Yeah.
Yeah, but what there are a lot of, many of you I'm sure know Sheet Music Plus Press or SMP Press, is that that's sort of a middle ground between doing it yourself and having a selling platform. It's almost like an Etsy kind of situation, where you can put up your own arrangement, sell it through their framework, which is a really good machinery to be seen, and then they collect the money and pay you a percentage of it. And you can do that with things where you own the copyright, either to your own original work or your arrangement of a public domain piece.
Yeah.
Or because Sheet Music Plus is now part of Hal Leonard, which represents so many pop songs. There's a tremendous amount of pop music that is licensed through SMP Press, so you can do arrangements of pop songs. Okay, I'll confess, I just did one for clarinet sextet of I Can See Clearly Now, that Johnny Nash song, and I don't have the rights, but I know that I can release it through SMP Press.
Yeah.
And that then it will be legally legitimate. And so, I mean, even what Michael's talking about with his transcriptions of new scorings of standard repertoire.
Yeah.
You're entrepreneurial, you can sell it yourself. A lot of people don't want to sell it themselves or have their own shopping carts. And so there's SMP Press. I think J.W. Pepper has a platform like that, Finale and Sibelius. I know they used to.
Yeah.
Many of you probably know whether or not they do, but there's a lot out there.
Yeah. Michael asked a great question. Have you run into composers who are exercising a 35-year copyright law? Answer is yes. Now, let me explain that. That's called termination, okay? You as composers, if you create a work and you sign with a publisher and give the publisher the rights to your work, there are two types of ways to get back your copyright, okay? Or actually three, but the first way is if you unfortunately pass away before the copyright term expires, but let's not get into that one. If the work was created prior to 1978, it's 56 years. 35 years after 1978 that you signed a contract, not the copyright. You signed a contract with a publisher. Basically, under the law now, you can what's called terminate that grant of the copyright 35 years after you sign that agreement with the publisher. Okay, that's called termination. The whole idea of termination is that basically the Congress believed that a publisher had a lot of time to get wealth off of these works, and therefore let's give it back to the composer. Now, the 35-year and the 56-year termination rights are very, very specific. If you make a mistake in your notice to the publisher that you're exercising those termination rights, you're done. You're going to lose and you're not getting your copyright back. This is under section 304 and 203 of the Copyright Act. It's very specific, okay? You have to set forth your name, the contract date, if it's 56 years, the copyright date, not the copyright date for 35 years. You have to say when specifically the 35 years or 56 years expires, okay? And it has to be signed by either you as the composer, or if you've passed away, it's your spouse, or if your spouse has passed away, your children. If you don't have a spouse and you don't have any children, it has to be the executor of your estate. It can't be a trust. It can't be your best friend Irving. It can't be these. It's very, very specific. That's why there are a lot of errors. And to be honest with you, I have received these, and in basically everyone I have received has been wrong. Okay, and therefore the terminations did not occur.
Jay,
Yeah.
we're way
We're way
over
over.
time. The Carnegie Hall stagehands are coming after us.
Yeah, I know. Okay.
With
I just
overtime
wanted to
bills.
answer Mike. Michael had a great question. I just wanted to answer his question. He had a great question.
No, they're all great questions.
Yeah. What
Well,
I
I
just
want to
say,
thank everybody
yeah.
for coming to hear us. I always think when Jay and I do this a bunch, and I always think, who wants to hear us talk about copyright? You want to hear about music, but Jay's so interesting that this always happens.
Yeah. Okay, I'm gonna go I'm gonna go coach lacrosse right now, which is a good day for me. So I really, really thank you, Jessica. Thank you so much for having me. And anytime anyone has any questions, I mean, please, I'm more than happy to help, because you, like I said, and I'll say this one time real quick, you guys are creative people, and your creative talents, you deserve to be paid for your creative talents. So thank you very much, and have a great rest of the weekend.
Any questions? Yeah, any questions, email me. You can find my email online easily, Facebook, my website, whatever. And I will see you all at our live convention this summer.
Yeah. Okay, take care. Bye-bye.
Okay, bye.